Good afternoon, everybody. I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please call the roll?
Senator Flores, Senator Orangel,
Present.
Senator Lang, Senator Wynn, Senator Hansen, Senator Krasner, Senator Ellison, Chair Scheibel.
I am present. Will you please mark Vice Chair Flores present when he arrives? And welcome, everybody. Sorry to those of you who are here for the work session. We will not be doing that first. But I do have good news. We are going to do the following bills in a consent agenda when we do the work session. So if you're here for one of the bills I'm about to read out, that means that as of right now, knock on wood, no one has any questions on them. So if you were here for SB 203, 240, 256, 323, or 383. Those are going to be done in a consent agenda. We'll still be work sessioning SB 142, 152, and 241 today. The last three just won't be on the consent agenda. So hopefully that gives you kind of some information so you can plan your day. And with that, I will go ahead and open up our first hearing on SB 341.
Chair Scheibel, members of the Senate Committee on Judiciary. For the record, my name is James Orangel. I represent State Senate District 21 down in Southern Nevada. I want to thank you for hearing Senate Bill 341. I'm very fortunate to have with me down in Las Vegas co-presenting Mr. Scott Coffey. He's now a private attorney in private practice. He just recently retired after 30 years at the Clark County Public Defender's Office, where he retired as chair of the homicide team. He currently practices in that same area, homicide cases, death penalty cases, and he's got tremendous familiarity with the subject matter in SB 341. So, Chair, with your permission, I'd like to turn it over to Mr. Coffey. Then I'm happy to stand for any questions.
All right. Thank you, Senator Orangel, and it's a pleasure to be here this afternoon presenting with you. SB 341 is an attempt to codify something that was adopted by the Nevada Supreme Court in 2023 and went into effect in February of 24, and that would be 80 KT 581, which talks about audiovisual testimony. As written, but I think there is a potential for amendment because of some practical difficulties with the 10-day deadline as written. What it seeks to do is to clarify when audiovisual testimony can be used. What we hope the members of the committee are aware of is the importance of preliminary hearing in Nevada. Our trial rates are vanishingly small. We go to trial in Clark County less than 0.5% of the time. Actually, it's quite a bit less than that. With that, it means preliminary hearing is the only opportunity that we are given to see witnesses, to see how they will testify, to actually put them under oath and take testimony. About 20 years ago, this body adopted NRS 171.1975, which allows for the use of audiovisual testimony. In all candor, it's not used that often. It provides for audiovisual testimony when someone resides more than 100 miles from the location of where the testimony will be taken. Also, if they have some kind of medical situation. And there's a third provision for good cause. Now, I don't know exactly what good cause means. I'm not sure anyone does. But what had happened during COVID is that good cause provision started to get used a bit loosely. And we have people that would be testifying by audiovisual means. If you have any question about whether audiovisual is the same as being in person, just take my testimony at face value. I'd much rather be in the room with you in Carson City talking to you directly than, as nice as this facility is and as good as the audiovisual testimony is. I'd much rather be in the room in Carson City where I could answer questions, look at people directly. You could get a feel for what I have to do and say. And I will tell you that is with a state-of-the-art situation. When we are in the courtroom, and I have done depositions in capital cases by audiovisual means, we have witnesses who are sick, who are unable to travel. It is inevitably a mess. Part of the reason it is inevitably a mess is, as good as the audiovisual technology is, it is not perfect. It is hard to gauge somebody's expressions. It is hard to gauge someone's reactions. The formality goes away. In a preliminary hearing, generally you have some kind of formality, right? Where a person has to come in, stand up in front of people, say something. It is very different when they have to testify from their own room with other people in the room, you know, children, dogs, whatever it might be. And we've seen all of this. So the goal of this bill is essentially to limit audiovisual testimony to when it is actually necessary. When someone is sick, when someone has a legitimate medical excuse, when the distance makes travel impractical. I think this bill helps, believe it or not, resolve cases, and not just resolve by dismissal. I think it helps resolve cases on the ground level. When I represent a defendant, if someone comes in or tries to testify by audiovisual testimony, inevitably what happens is a defendant will be concerned that the person may not show up for trial. And audiovisual testimony, by the way, may not preserve the testimony for trial because it doesn't meet the standards for the Sixth Amendment that we normally have for trial proceedings. It makes it difficult for defendants, for judges, for prosecutors to evaluate what the testimony is. And with that in mind, I think it makes sense to require live testimony the vast majority of the time. Preliminary hearings are obviously scaled down. They are not trial. If I have a preliminary hearing with 4 witnesses, perhaps it'll be 20 at trial. So we're not talking about a huge burden of bringing these people in to give live testimony. But it is, I think, a huge importance for people to even just have a conversation. I don't know how many cases I have resolved with victims, families, other people in the courtroom, witnesses in the courtroom, where we have the opportunity to talk with a district attorney. The provisions right now, again, call for 10-day notice. I don't think that's practical with a 15-day set for preliminary hearing, which a defendant is entitled to. I think Mr. Orenshall, Senator Orenshall, would be amenable to amending that to 48 hours. There's some additional language that I think clears up part of what would be asking for. But again, I think the underlying importance of this is to try to get live testimony whenever practical. I think it helps the system. And if you have any questions, I'd be happy to answer them.
Thank you. And Chair Scheibel, James Orenshall, State Senate District 21. There is a conceptual amendment that I submitted. Hopefully it's on Nellis and members can view it. And it does propose amending the time to 48 hours.
All right, thank you so much. And that concludes your presentation. I just want to confirm.
That's correct, Chair. Thank you.
All right, questions from members of the committee, starting with Senator Ellison.
Thank you, Madam. I don't know if you can answer this or him. I know that you're looking at doing the video and you'd rather have them in court, but what do you do when the courts are doing them in jail and the judge is in the courthouse? Would this create a problem, or what if you're way out in the rural area and you need, the only way you're going to get is the video?
Senator Ellison, if I might, I don't think it creates an issue.
If you could just state your name for the record.
Oh, I'm
Sorry.
Scott Coffey again. I don't believe, Senator Ellison, that it does create a problem. There are provisions in the ADKT, the administrative order from the Supreme Court that I mentioned, that allow for certain things to be done audiovisual. That would include status checks, that sort of thing. Situations where, say, the attorney is from one of the major metropolitan areas and they're appearing in a rural courtroom. But the expectation is for preliminary hearing, which is a very critical stage. And again, I would say in Nevada, It's about as close to trial as we get in 99% of the cases. It makes sense to have the people there. And the defendant has to be present for a preliminary hearing. As it is currently, I've never had a preliminary hearing where, absent a agreement of the parties, that a defendant was not present in the courtroom. So I think that's managed right now without too much issue.
And Chair Scheibel, if I could jump in, James Orenshaw, State Senate 21, the ADKT that Mr. Coffey referenced 0581, I did submit. Hopefully it's on Nellis, but I do have a hard copy if anybody wants to look at the paper copy.
Thank you, and it was just uploaded to Nellis, so if you refresh your page, you'll be able to see it now. Other questions from members of the committee? I just wanted to clarify a couple of things with this because but basically the current state of the statute is that there are no deadlines, timing requirements for these affidavits to be filed at all. Is that correct?
Chair Scheibel, Scott Coffey, that is correct. There are no timing requirements. The requirement is good cause. Inevitably, what happens is people are scrambling the morning of preliminary hearing. And I understand and am empathetic to the fact that district attorneys sometimes get late notice about situations, but there is a provision that wouldn't necessarily mean the case would be dismissed. If you miss this deadline, the state could ask for a Hill or Bustos motion, ask for a short continuance, or I would assume the parties could agree to do the audio-visual testimony if they preferred that to a continuance. So it wouldn't be a situation where a case would be dismissed. It would be a situation where we have notice, and we could actually look at whether or not somebody was sick, whether or not they're actually out of town, those sorts of things.
And thank you. I think you just answered my next question, which is what the remedy would be for failing to meet these deadlines, because having also practiced in Clark County, having also done dozens, if not hundreds, of these preliminary hearings, I think it is important for a party to know, and I also read this to apply equally to the prosecution and the defense. If either party intends to have a witness testify by audiovisual technology, the other side is entitled to know that before they come into court, because I think it does absolutely change the way that you approach a witness. I'll just, get on my soapbox for a second and say that there's nothing more frustrating than being in court when an attorney tries to do handle a proceeding that requires an in-person witness, and they try to do it over Zoom, and they're holding up papers, and they're like, do you recognize what this is? And of course they don't, because you can't see it on a screen, and you need to be there in person. So I appreciate that both sides need to be alerted to the fact that someone's going to be bringing in a witness on audiovisual technology. And it looks like it doesn't provide a remedy. So if I am a defense attorney, which I am, and I get there in the morning and I find out that the state wants to utilize audiovisual technology and they haven't filed the proper notice, what this does is this gives me a choice. I can either waive the notice requirement, go forward with the hearing, or then I now have standing to say to the judge, look, I was entitled to know this 48 hours prior. I'm not prepared to go forward with an out-of-state witness. I'm not prepared to go forward over audiovisual technology because that changes how I would present them with evidence, how I would cross-examine them. I'm entitled to my 48 hours to prepare and get the preliminary hearing reset. Is that the idea?
Scott Coffey again to Chair Scheibel. That's exactly the idea. You put it very eloquently. And that's exactly the concern that we're trying to address here. Look, court is a formal proceeding. And when we take the formality out of it, just as this body is a formal proceeding, when you take the formality out of it, you get different answers. You get different approaches. You get different, people don't take things as seriously. And that becomes a concern. We've all seen cases where witnesses go out of their way to make things up, for lack of a better description. It doesn't happen often, but it does happen. And it's a lot easier to see it if you have the person there in the room with a judge looking at them, a prosecutor looking at them, defense attorney looking at them.
And one last question. I guess this doesn't change the current status of the law in terms of there not being a mechanism for the opposing party to object to the use of audiovisual technology, and it also doesn't require the judge to make a decision about whether or not to allow this technology, just as long as, I guess, the judge gets to make the good cause determination. But other than that, it's just a notice. It's not a motion requesting permission, right?
To Scott Coffey, again to Chair Scheibel, that is the way that I read the conceptual draft that was put together and the statute as it currently stands. I think that's correct.
Thank you for clarifying. All right, based on that, are there any additional questions? I'll also note that members of the committee did just receive a copy of that ADKT 581. But I don't see any other questions. So we will move now to testimony in support of SB 341. Anybody wishing to testify in support in person is invited to the front now to give that testimony.
Good afternoon, Angela Knott from the Washoe County Public Defender's Office, ANGELA, KNOTT. We fully support SB 341, especially with the amendment of the 48-hour rule. We are actually already seeing this practice in Washoe County. We've already had cases where the DAs are filing the notice and the affidavit ahead of time before the preliminary hearing. But it's important to also note, I've had 2 preliminary hearings now. And when the witness was presenting on the audio-visual, twice now did we realize that someone else was present with the victim on the video. And we had to have a whole conversation. So take it away from the preliminary hearing, what's happening, and have to have a whole conversation with the victim on the video about not conversing with another person who's just off screen of the video. It is an issue. We prefer in person, but if not, then give us 48 hours so we can prepare and we can have rules to follow. Thank you.
Good afternoon, members of the Senate Judiciary Committee. Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-R-E-R-O, on behalf of the Clark County Public Defender's Office. The important part of this bill is really the notice piece. It's an entirely different strategy when we're cross-examining a witness in person versus audiovisual testimony. Especially if, as a defense, you're bringing in exhibits that are other documents or videos, then it's an entirely different way, a process to do it if we have to figure out a way to do it through Zoom. So it's really about preparation. Additionally, limiting the use to situations where it makes sense is important. When someone is an audio-visual, you can't read their body language, you can't assess their credibility properly, you don't know if someone else is in the room with them, you also don't know if they're reading off of something. I had a preliminary hearing where thankfully they're being pretty obvious about it, and every time I asked a question, they would look down and reference up when saying certain facts, and so we were able to just cross-examine them on that, and it turns out that they had a phone that they were referencing and getting information from, which is something you're not allowed to do and something that would not have happened if they were in the courtroom in person. So we urge your support on this bill. Thank you.
Today. Sorry about that. Do we have any other testimony in support in Las Vegas? I see Mr. Coffey still at the table. I don't know if there's anyone else that needs to testify in support. Can we go to the phone lines?
Thank you. The public line is open and working. There are no callers at this time.
Thank you. If we could next move to, it's really slim pickings here. If I'm I think I'm third down on the list, you guys, to chair when people are out. So I apologize for that in advance. If we can go now to opposition testimony, if you can fill in the chairs and begin when you're ready.
Thank you, Vice Chair Wynn. My name is John Jones, here on behalf of the Nevada District Attorneys Association. We are in strong opposition to SB 341. And I want to start off by saying I believe even the presenters conceded that this isn't something that's used very often. I think all of us prefer in-person testimony. And I worked on the current version of this statute back in 2015. I don't know if Senator Hansen remembers, but he was chair of Assembly Judiciary when we worked on this statute. Our position is that the current statute is not unnecessarily burdensome and is appropriate for all of the circumstances that I see as a district attorney. But before I start, I want to point out that prelims are not meant to be mini trials. A full and complete exploration of the facets of the case are reserved for a jury trial, not for prelim. And I'll point out that many states don't even require a victim or a witness to show up at prelim. Hearsay can be admitted. Others don't even require a prelim at all. But because Nevada requires victims and witnesses to testify, not only at trial, but also at a preliminary hearing, our position is we should make it as easy as possible to elicit their testimony, especially at these early preliminary hearings. Our first issue, and it's not clear to me whether or not the amendment addresses this, but it's with the good cause language being removed in sections 1 and 2 of the bill. There are reasons not contemplated by our statute where a person who resides within 100 miles of the courthouse or is otherwise healthy won't be in town. They could be out of town for work. They could be on military leave. They could have family emergencies or vacations. We should leave it to a judge to determine whether or not these situations are valid and whether or not video testimony should be allowed. We should not remove the good cause exception. Second, one of the jobs I have as a DA is locating victims and witnesses, and sometimes it's difficult. I'm not going to lie. This bill assumes that all victims have a fixed residence, a phone, and are instantly responsive to our process servers and investigators, but I can tell you that they are not. I have had many a prelim where it's the night before and we have just located our witness and found out that they're in Indiana. So under this bill, I would not be allowed to call them at prelim. I disagree with the presenters of the bill saying this would allow a continuance. No defense attorney is going to request a continuance when they know one of my witnesses are in Indiana. This is going to lead to more dismissals. Finally, Mr. Coffey, I believe, indicated that a defendant has to be present at a prelim. In fact, they do not. There's a case right on point called State versus Sargent. And in fact, it's important to note that a defendant may file a sergeant notice the day of prelim. They do not need to give the state any notice that the defendant is not going to be present in prelim. There is no reason to require a victim and a witness to file this notice 10 days or even 48 hours before a hearing when a defendant can waive their appearance the day of the prelim. I appreciate Vice Chair Nguyen the opportunity to oppose the bill, and if you have any questions, I'm more than happy to answer them.
I actually do have a question for you, if that's okay. I think you're the two people in opposition. You're probably in the best position to answer this question. You had indicated, obviously, a preliminary hearing is not the same thing as a trial. However, if you had a situation where there was a preliminary hearing and it was done by virtual means, and later you could not find that witness or that victim or any of that participant, there is a process where you would be able to use that testimony at a trial. Isn't that correct?
John Jones, on behalf of the Nevada District Attorneys Association, yes, we can use, as long as it's a sworn testimony and subject to cross-examination, we can use that testimony at trial with the judge's permission, of course.
And so in that circumstance, you would never have the right to cross-examine that witness live and in person without kind of, you know, if you had, like, you're holding up papers and exhibits over like an audio-visual. Do you think that's a fair, accurate opportunity to fully cross-examine a witness and to be able to use that testimony later in trial?
John Jones, on behalf of the Nevada District Attorneys Association, actually I do. There is no right necessarily at a prelim stage to in-person cross-examination. And I would argue that under our current law, if a defense attorney feels that they are prejudiced by video conferencing or video testimony, then they are perfectly within their right to request a continuance. The remedy at the preliminary hearing stage for issues like that is a continuance. So I think the statute is unnecessary in that if a defense attorney feels that a video testimony in this instance is inappropriate, they can request a continuance and let the judge decide. I'd also like to point out that the Supreme Court has set these rules in ADKT 581. I think Mr. Coffey indicated that this was his attempt to codify those rules, but I can tell you that what's in SB 341 goes well beyond what the Supreme Court codified in those rules.
Thank you. Do we have any other questions? And I see the chair is actually back, so thank you for answering my question.
All right, then, we will go ahead.
Thank you, Chair. Members of the committee, for the record, Kelly Crompton representing the City of Las Vegas. I'd like to echo the remarks from the District Attorney's Office. We are concerned about the utilization of discretion in determining whether good cause exists, and that therefore we are in opposition today. Thank you.
All right, not seeing any other further opposition testimony in person in Carson City, just confirming there's nobody to testify in opposition in Las Vegas. We will go to the phones for opposition testimony.
Thank you, Chair. The public line is open and working. There are no callers at this time.
Okay, then we will go to neutral testimony. Anybody wishing to testify in neutral is invited to do so now. I don't see anybody coming forward in person in Carson City or Las Vegas, so we'll go to the phones for neutral testimony.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then. I'll invite the sponsors forward to give any closing remarks.
Chair Scheibel, members of the Judiciary Committee, James Orenshaw, State Senate 21. Just directing everybody to the proposed amendment. I do believe that the 48 hours notice is something that comports with many other standards. In practice, it's fair to both sides and it's required to both sides. With your permission, Chair, if I could ask Mr. Coffey just to address a few points in his closing as well. Thank you.
Thank you, committee member Scott Coffey. The 48 hours is embodied in ADKT 0581. That is what the notice requirement is in ADKT 0581. So while the opposition had said that there is no connection, this goes on well beyond 0851. I do not believe that it does. As far as being absent at preliminary hearing and sergeant notice, that is a right exclusively for the defendant. The defendant has a right to be physically present at a preliminary hearing, period. I know of no exception to that. When we talk about sergeant notice, it's a very different situation. Sergeant notice is a situation where you've got concerns about the identification or out-of-court identification, and a defense attorney can unilaterally waive his client's presence, but that is a defense attorney, not the state. We talk about these aren't many trials, but then out of the next breath, we hear that it might be used at trial. And obviously that's really the big concern here, right? Preliminary hearings are not many trials, but we think audiovisual testimony is good enough, and doggone it, if we can't find the person later, that should be good enough for trial too. That is problematic. That is the question that Senator Nguyen asked. And it probably runs afoul of the Sixth Amendment. I think if we got to the point that we started doing that on a regular basis, you would see a lot of time in federal court with litigation pursuant to Washington v. Crawford, because you do have a right to confront and cross-examine your accusers. In Nevada, again, because of the low trial rate, less than 0.5%, the only time that effectively happens is preliminary hearing. So I find it concerning when we minimize the importance of preliminary hearings. Any defense attorney that I know realizes how important they are. I think prosecutors do too. The chair of this committee was a prosecutor for quite some time, and I think she recognizes the importance of preliminary hearing. And to minimize this and say, let's just make it easy for everybody, disregards something very critical. And that is that we have accused somebody of a felony crime. If we're having a preliminary hearing, that's what we're talking about, a felony crime that will stay on the record the rest of their life. And we want to make sure that it's done right. And doing it right means bringing people in to testify, not having them testify via cell phone, which is what this devolves to inevitably. So with that, I hope that you support SB 341. If there is anything else, I'd be happy to answer.
Thank you. I think that concludes the hearing on SB 341. At this time, if you hold on one second, Senator Hansen, I'm going to strike while the iron is hot, meaning everybody is here. They've either returned from their other presentations or haven't left for them yet. We're going to do our work session. Senator Ellison wants to do his by video. But he didn't tell me 48 hours in advance, so you have to stay here with us. Let's go ahead and open up the work session. We will start with SB 142, and I will turn it over to our committee analyst to walk us through the work session document.
Thank you, Chair. This is Jared McDonald, Research Division, LCB. The first bill on your work session is Senate Bill 142. This bill revises provisions governing property that is exempt from execution. It was sponsored by Senator Doñate and heard in this committee on February 19th. The bill revises the monetary amounts exempt from execution and requires those amounts to be adjusted by the Department of Business and Industry on April 1, 2026, and every 3 years thereafter, an amount equal to the percentage of increase or decrease in the Consumer Price Index Western region. And we did receive one amendment from Senator Doñate, and that is on the next page. This amendment would replace the Department of Business and Industry with the Department of Taxation. Thank you, Chair.
Thank you, Mr. McDonald. Any questions on SB 142? All right, I would accept a motion to amend and do pass.
So moved, Madam Chair.
Second.
We have a motion from Vice Chair Flores. We have a second from Senator Orenshaw. Any discussion on the motion? Senator Hansen.
Thanks, Madam Chair. We discussed this briefly before the hearing. I'll be voting no because I think the dollar amounts are excessive. I am fine with the provision in it where we do adjust things for inflation, but in my mind, when people have the amount of dollars left in their accounts that this bill currently suggests, they should be held financially responsible to pay their bills. So I'm a no on this, although I do think the adjustment for inflation is fully justified. Thank you, Madam Chair.
Thank you, Senator Hansen. Any other discussion? Not seeing any. All in favor, aye. Aye. Any opposed, nay. All right, for the record, the nays are Senators Krasner, Ellison, and Hansen. The rest are ayes, so the motion to amend and do pass does pass. I will assign this floor statement to Senator Doñate. And that takes us to SB 152.
SB 152 enacts provisions related to electric vehicle charging stations in a common interest community. This was sponsored by Senator Orenshaw and heard on March 5th. Senate Bill 152 prohibits the executive board and governing documents of a homeowners association from prohibiting a unit's owner or occupant from installing or maintaining electric vehicle charging station within the physical portion of the common interest community the unit's owner or occupant has a right to occupy. The bill also authorizes an association to install an EV charging station in a common area under certain circumstances, authorizes an association to enter into a contract for the installation or maintenance of an EV charging station in a common area, and provides that the installation and maintenance of an EV charging station in the common area does not constitute a change in the use of the common area, commercial use of the common area, or capital improvement. And we do have one amendment proposed for this bill. And this was discussed in the hearing, and it is on the next page. If you'll recall, Senator Orenshaw proposes to delete subsection 1 of section 1, prohibiting an executive board and the governing documents from barring a unit's owner or occupant of a unit from installing or maintaining an EV charging station in the physical location of the common interest community the owner or occupant has a right to occupy and use exclusively. The amendment also adds language clarifying that association may, after complying with NRS 116.345 subsection 3, install an EV charging station, and the placement of the EV charging station may not increase any cost to any unit owner. And then finally, the amendment provides that the installation is not rejected by a majority, if that installation can only be rejected by a majority vote of the unit's owners at the regular board meeting. Thank you, Chair.
All right, looks like we have a question on SB 152. Senator Krasner.
Thank you, Chair. I'm sorry, I haven't seen that amendment. And I don't see it on Nellis. Is it in there?
There is an amendment in your work session binder. All right, any other questions? Senator Hansen.
Thanks, Madam Chair. I had a chance to talk to the bill sponsor, and Senators Krasner, Ellison, and myself met previously, but we hadn't seen the amendment. After seeing the amendment, ironically, I wish you would have left in part 1 they took out, but now the amendment makes most of the concerns I had go away, so I'm going to be a yes on this as amended.
All right, Senator Krasner.
Yes, with the amendment, I am now a yes on this bill. Thank you.
Any other discussion? Seeing none, I will take a motion to amend and do pass. All right, we have a motion from Senator Wynn.
Second, Madam Chair.
And a second from Vice Chair Flores. Any discussion on the motion? Seeing none, all in favor say aye. Aye. Any opposed, nay. We have a unanimous vote to amend and do pass with the amendment that is reflected in the work session document. And I will assign the floor statement to Senator Orenshaw. At this time, we're going to skip to SB 241.
Senate Bill 241 revises provisions related to juvenile probation. This bill was sponsored by this committee and heard on March 12th. The bill limits juvenile probation to 18 months and extensions of probation to a total of 36 months. The bill also authorizes the juvenile court to terminate the period of probation of a child who has failed to make full restitution but has otherwise fulfilled the conditions of his or her probation. And then the last piece, the bill requires the juvenile court to hold a hearing before suspending, modifying, or revoking the probation of a child or placing a child in a detention facility or county jail. And we do have one amendment that was proposed by a group of agencies. We have the Clark and Washoe County Public Defender's Office, the Washoe County Department of Juvenile Services, and the Clark County District Attorney Juvenile Division. They got together and submitted an amendment that is on the next page. And this amendment proposes to amend the bill to clarify that if a child is adjudicated delinquent for more than one offense at the time of disposition, the term of probation shall not run consecutively for each adjudicated case. The amendment also provides that any amount of restitution that remains unpaid by a child or a parent or guardian of a child after the termination of probation constitutes a civil liability and remains under the jurisdiction of the juvenile court. And then finally, the amendment deletes subsection 5B of section 2 and adds paragraphs F and G requiring the court to consider the status of existing court orders and the juvenile's progress toward completing the case plan required by NRS 62E 507. Thank you, Chair.
All right. Okay, we have a question from Senator Hansen.
Thanks, Madam Chair. We briefly discussed the bill earlier, and the question of creating a civil liability, as I understand it, you get in trouble, you cause $10,000 of the damage. Part of the penalty is that you are going to make restitution. You haven't been able to get that done during the time that you thought you would, and we are going to eliminate probation after the 18-month window, but then the question of the restitution that came up, and you and I discussed it briefly. As the bill currently is constituted, it becomes a civil liability. Now, at that point, legal question for me, does that mean the victim would then have to go to a court and essentially sue to get the bulk of his restitution? And if that's yes, then that's a big red flag for me. But under the amendment from the public defenders, it says it stays basically the juvenile court maintains jurisdiction. Now, how does that change the civil liability aspect of this?
James Orchall, Senate 21, through you, Chair, to Senator Hansen. The way I see cases now as a practitioner, in juvenile court, very often, if, let's say, a child has finished all their orders, they've stayed out of trouble, very often I'll see the juvenile court judge convert that child to what's called probation without supervision, where technically they're on informal probation, they're still trying to make payments off towards that restitution. So let's say a child steals your car and unfortunately gets in a car crash and there's $10,000 of damage. And the judge orders 9 months of probation, class as community service, and pay off Mr. Hansen's restitution. And during the 9 months, let's say the child and their family have been able to make payments, but they've only paid $2,000. And at the 9-month point, the juvenile has finished all the orders, stayed out of trouble, but still owes $8,000. Now, under current law, what I see is very often, in most cases, the juvenile judge will convert the child to probation without supervision, still try to make payments, and if, as the 21st birthday gets closer, because that's when the juvenile court loses jurisdiction over that child, it doesn't look like they've made much progress on paying off the restitution they owe you, then I'll see that conversion to a civil judgment. And where that's something that you could collect on against the child, and usually their parent or guardian as well, depending on how the judge orders the civil judgment, words it. What I see this bill changing is that the child, that same child who's done well on probation during the 9 months, finished all the orders, stayed out of trouble, but still owes you $8,000 of the $10,000, could have their probation terminated completely. The juvenile court would retain jurisdiction over the restitution. It wouldn't go away, the debt they owe you, and it would still be eligible to be converted to a civil confession of judgment as their 21st birthday approaches. So the effort to make you whole wouldn't change, but there'd be a realistic, achievable goal for the child of when probation could end. So that's what I see as the benefit.
So do you see the amendment as a friendly amendment? Because it sounds like basically they're keeping the current system in place under the amendment.
If I could, sorry, is it friendly?
James Orchall, Senate 21. I know that Washoe County worked with Clark County and the public defenders, and I consider it friendly. I hope the rest of the committee considers it friendly, but I know that everybody worked very hard to try to reach consensus on this.
Okay, well, no, my concern is just I don't want a victim to have to go to court to enforce a civil liability against somebody that didn't pay the restitution. So if it remains the way the current law is, if the individual reaches age 21, it automatically is converted to a civil liability, what I'm understanding. So is that still what will happen if this amendment, or if your bill passes as is, or if the amendment happens? Is it, what changes here? I'm kind of confused.
I believe that restitution owed, even under the amendment, could still be converted to a civil judgment in terms of the victim and their family collecting on that. In terms of what has to be done, I believe it would be like any other judgment that you're seeking to enforce. And here, with your permission, Chair, I might need to defer, if it's okay, to your legal counsel as to how that's collected after effect in terms of other judgments. So.
Thank you, Chair. Yes, the bill and the amendment both don't change how restitution in the civil judgment works. It's just the period of probation that's affected. So the NRS 62B 420 actually sets forth what kinds of actions can be taken to collect a judgment. And scrolling through here now, basically the victim, a representative of the victim, or a state or local entity that's responsible for collecting it can report it to collection agencies, request the court take appropriate action, which would include ordering a driver's license suspension, for example,
contract with a collection agency directly to collect the judgment. So, and that's not being changed by the bill or by the amendment. That's just how it works currently and would continue to work.
Senator Ellison.
There really wouldn't be any need to do that because the judgment would already be entered in a specific amount. So at the time they determine and enter that civil judgment, the amount would be set.
Thank you.
Any further questions? Senator Krasner? Yeah, on 241.
Is it possible to ask a question of one of the members of the District Attorney Association on a clarification?
I don't think we have the district attorneys here who brought forward this amendment, so I don't think we have.
Can one of them answer?
I don't want to put our district attorneys on the spot who weren't responsible for drafting this amendment. But we're going to try it anyway. Thank you for being a good sport, Mr. Jones.
Thank you. So, thank you, Chair. So on SB 241, I know I asked you these questions before, but I still have concerns, and I'm getting concerns from members of the public regarding sexual assault. And we're on SB 241. So currently for sexual assault, what, say a 17-year-old rapes a 14-year-old, what's happening there in a situation like that?
John Jones on behalf of the Nevada District Attorneys Association. In terms of juvenile court, I will point out 62F110, which requires that if a juvenile is adjudicated delinquent of a sexual offense, they must be on parole or probation for a period of not less than 3 years. It's my understanding this bill does not affect parole or probation for juvenile sex offenders at all. It would still be a minimum of 36 months.
And if I may, so and then in section 1, subsection 2, section 1, subsection 3A, it says that currently a juvenile court shall not place a child on probation for a period of more than 18 months for each unlawful act for which the child is adjudicated delinquent. So let's say they first choke somebody else and then they sexually assault the person. Currently, that would be 2 separate offenses where they would receive 2 different.
So I'm sorry to interrupt, but at this point, we're really getting away from the bill. SB 241 is about cases where there is restitution ordered.
It's changed, though, in the bill. The language has changed. I'm asking about language that's changed in the bill. I can ask later. I could just vote no and ask him later. It's okay.
Okay. Not seeing any other questions on this bill, I will accept a motion to, I have one more question or comment. I do notice that the amendment does not include changing all of the shalls to mays to give juvenile judges discretion to allow juveniles to keep their driver's licenses. But I'm guessing that was intentional. So I will accept a motion to amend and do pass SB 241.
Second.
I have a motion from Senator Wynn. I have a second from Vice Chair Flores. Any further discussion on the motion?
Chair Scheibel.
Senator Orenshaw.
Thank you. At the earlier hearing, I made a disclosure regarding a conflict on SB 241 that I made to the committee. I'd like to make that same disclosure, and after my conversation with Legislative Council, I was told that I am allowed to go ahead and vote on this bill, and as long as I made that disclosure. So I'm just making that same disclosure about the conflict.
Understood. Thank you. All right, all in favor, aye. Aye. Any opposed, nay? All right, we have one nay from Senator Krasner. The rest are ayes, and I will assign the floor statement to Vice Chair Flores. And with that, we will move to our newly created consent agenda on SB 204, 240, 256, 323, and 383. Mr. McDonald will briefly walk us through the work session documents on those bills.
Thank you, Chair. Senate Bill 203 provides immunity from civil liability for certain agencies, entities, and persons related to the pari-mutuel system of wagering. This was sponsored by Senator Brasina and heard in this committee on March 6th. The bill provides the state of Nevada, the Nevada Gaming Commission, the Nevada Gaming Control Board, the Off-Track Pari-Mutuel Wagering Committee, and certain other persons are immune from civil liability for any decision or action taken in good faith and without malicious intent. We do have an amendment that was proposed for this bill, and this was submitted by Virginia Valentine, President of the Nevada Resorts Association. And they proposed to amend the bill to make various changes to Chapter 463 and 464. And they did supply a detailed summary on the next page, which is followed by their conceptual amendment that summary describes. And I will move on to the next bill, SB 240. Senate Bill 240 revises provisions related to state business licenses. This was sponsored by Senator Pazina and others. It was heard in this committee on March 11th. The bill reduces the fee for the issuance of an initial state business license to $100 for certain businesses which employ not more than 50 full-time or part-time employees. And we do have one amendment for this bill that was discussed in the hearing. If you'll recall, the Vegas Chamber proposed to amend the bill to delete language reducing the fee for corporations organized pursuant to Chapter 78, 78A, or 78B of NRS, or a foreign corporation required to file an initial annual list with the Secretary of State pursuant to Chapter 80 of NRS. Moving on to our next bill, Senate Bill 256. Senate Bill 256 revises provisions related to gaming. This was sponsored by Senator Wynn and heard on March 12th. This bill requires a person to disgorge any profit, gain, gross receipt, or other benefit resulting from certain illegal gaming activities and pay that amount to the state treasurer for deposit in the state general fund. The bill also increases the penalty from a misdemeanor to a gross misdemeanor for accepting, receiving, or allowing certain persons to accept or receive certain wagers under certain circumstances. And we have no amendments proposed for this bill. The next bill is Senate Bill 323. This bill revises provisions related to offenders. It was sponsored by Senators Scheibel and Cruz Crawford and others and heard on March 13th. This bill makes permanent a pilot program requiring the Nevada Department of Corrections to provide telephone calls between female offenders assigned to Florence McClure Women's Correctional Center and their family members free of charge. The bill also prohibits the department from charging offender more than the actual cost of the department for any audio or video calls made by or to an offender, and requires that if the department enters into a contract with a provider of communication services for offenders, it must comply with the provisions of federal regulations related to the return of money deposited into an incarcerated people's communication services account, as those regulations existed on January 1, 2025, and we have no amendments on this bill. And the final bill is SB 83. This bill revises provisions governing juvenile justice. It was sponsored by Senator Orenshaw and heard on March 20. The bill revises the definition of community service to include activities that facilitate civil engagement, provides training and life skills, or increases the employability of a child. The bill adds a program to build job skills and increase employability to the list of entities under whose supervisory authority a child, parent, or guardian is authorized to perform community service. The bill also provides the juvenile court with the discretion to suspend or delay the issuance of the driver's license of a child who is adjudicated delinquent or in need of supervision. Finally, the bill removes the requirement the court order to pay a fine the first time is adjudicated in need of supervision and authorizes the juvenile court to order the child to perform an additional 10 hours of community service or combined total not to exceed 20 hours. Thank you, Chair.
All right. Any questions about the consent agenda? Not seeing any questions. I would accept a motion to amend and do pass SB 203, do pass SB 240, do pass SB 256, do pass SB 323, and do pass SB 383.
So moved, Madam Chair.
All right, we have a motion from Vice Chair Flores, a second from Senator Wynn. And I think that was supposed to be an amend and do pass on 240. Would you like to amend the motion, Vice Chair Flores?
Yes, Madam Chair.
And will you still second it, Senator Orenshaw?
Yes, Chair.
Excellent. All right. That being the case, oh no.
Madam Chair, I move to amend and do pass Senate Bill 203, amend and do pass Senate Bill 240, do pass Senate Bill 256, do pass Senate Bill 323, and do pass Senate Bill 383.
Second.
Thank you, and thank you for the assistance, Vice Chair. Okay, that being the case, any discussion on that motion? Not seeing any, all in favor say aye. Aye. Any opposed, nay. Excellent. By unanimous vote, we are doing those things with those bills that Vice Chair Flores just said, and I will assign the floor statements as follows. SB 203 will be assigned to Senator Pizzina. SB 240 will also be assigned to Senator Pizzina. SB 256 will be assigned to Senator Wynn. SB 323 will be assigned to myself. And SB 383 will be assigned to Senator Orenshaw. We did it. We got through another work session. Great work, everybody. Thank you for hanging in there with me. And with that, I will close the work session. I will open up the bill hearing on our next bill on the agenda this afternoon, SB 361.
Thank you, Madam Chair, members of the committee. I am Senator Ira Hansen, representing District 14, which includes most of geographical Washoe County, all of Humboldt County, Pershing County, Lander County, and a huge section of Eureka and Elko counties. In fact, it's 38,000 square miles of Nevada's 110,000 square miles. I'm here today to present Senate Bill 361. This deals with tracking warrant. As I'm sure everybody here knows, we have the Fourth Amendment, which reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." So obviously when they wrote that in 1789 and it was adopted in 1791, they didn't take into account well, they did take into account, but they had no idea about the changes in technology. What this bill really deals with is a Supreme Court decision, Carpenter versus the United States, a decision in 2018, in which the United States Supreme Court put some pretty strict limits on what government agencies can do when it comes to tracking you through all sorts of different electrical devices. Now, when I first heard about this, there was a technology that was new at the time called Stingray, and the government had the ability to track you through your cell phone. What I didn't know, and one of the things that was fascinating about learning about this bill, was how many new forms of electrical devices you have. Like, for example, for those of you that walk around with one of those devices telling you how many steps you take every day, that is a tracking device that the government can use to track you. And there are a bunch of those now. So we haven't updated this statute, the statutes dealing with this type of technology since 2013. Obviously, with the Supreme Court decision in 2018 and with all of the advances in technology that are going on out there, we need to make sure that we come down, when these kind of issues come up, that we come down on the side of the people to make sure that they are protected from unreasonable searches by the government. And that's really what this bill deals with. I have to back up for just a second, though, because one of the things is, I love history. One of the fascinating things, why do we have the Fourth Amendment? I honestly didn't know. I've obviously read it numerous times. Well, the reason that we have it is because the king, when we were under the government of England, had a thing called a writ of assistance, which allowed essentially any government agent to search any part of you, your person, your houses, your property, your business, whatever, without any sort of oversight or need for probable cause. They also had a thing called a general warrant. Now, you'll notice we have in the Fourth Amendment, we can still have warrants, but they are very specific. The reason is because the general warrant that the king would put out would allow unlimited searches. And they didn't have to say, you have to go to this location and find and look for this or this or this. And because of that, when the Constitution was passed in 1787, the people in the United States at that time refused to pass the Constitution. It was actually rejected between the Federalists and the Anti-Federalists. So what happened? Well, to get it passed, they had to add a Bill of Rights, concept that goes back to English law. They actually have a written Bill of Rights. They don't have a written Constitution, but they do have a written Bill of Rights. So that concept was ingrained in the people of our brand new nation at the time. In order to get the Constitution, like I assume you guys revere it, I revere it. I always carry a copy in my suit coat. Got a bunch of them. So it wouldn't have passed otherwise. And one of the key reasons was because they didn't want the government to have this sort of general warrant power anymore. And so the Fourth Amendment was put in there to make sure that before a government agency, any government agency, could go and examine your person's houses, papers, and effects, they have to have probable cause. So that's the basis of this bill, because obviously since 1789 and 1791, the advances in technology have been phenomenal. Even in my life, even doing this bill, I've been shocked by how many things are new, even since we did some of this stuff back in 2013. All right, the bill, real quick, the actual summary of the bill. Sections 3 through 13 contain definitions for terms referenced in the bill, including tracking warrant, location information, and electronic device. Section 14 prohibits a governmental entity from tracking an individual without a tracking warrant and prohibits any location information obtained in violation of this bill from being admitted in any administrative, civil, criminal, or other proceeding in the state except to prove a violation of this law. Section 15 authorizes a magistrate to grant a tracking warrant if a complete application is supported by probable cause to believe that 1, the person is committed or is about to commit an offense, 2, the location information sought by the tracking warrant will produce evidence of an offense. Section 15 also establishes requirements for an application or extension of a tracking warrant. Section 15 also requires a magistrate to seal applications for a tracking warrant or extension. Section 16 sets the requirements for the contents of a tracking warrant and authorizes the applicant to request that certain provisions be included in the tracking warrant. The section also, 1, sets limitations on the time frame of a tracking warrant, and 2, authorizes the magistrate to extend the time frame under certain circumstances. Section 17 requires notification to the person who was tracked within 10 days before any trial, hearing, or other proceeding. Section 18 allows a person who is aggrieved by an unlawful search, an alleged unlawful search and seizure, to move to suppress that information in court. And Section 19 requires a magistrate to notify a person who is tracked not later than 90 days after the tracking warrant expired. Sections 19 and 20 make the notice containing information related to the information collected by a tracker confidential unless it is subpoenaed by a court of competent jurisdiction. So that's pretty much the bill. There is one slight error in the actual typo. Under Section 14, number 3, says it's a letter E. If you turn, let's see, 14, where am I here? 14.3, it says paragraph D. It should have been paragraph E. So that's a little typo that we caught. But other than that, Madam Chair, that's pretty much the gist of the bill and the intent behind the bill. So I would be happy to take any questions that anybody may have at this time.
All right, questions from members of the committee. Starting with Senator Ellison.
Thank you, Mr. Chairman. Madam Chairman. Mr. Hanson, did you say under section 14 that the judge could seal that record?
I'm sorry, what was the question again?
Yeah, you were reading it pretty fast, like trying to keep up with section 14. You said there was a part in there that the judge could seal the record. I can't find that.
Oh, I'm sorry, that's in section, I think it's section 19, Senator. Within a reasonable, there is, it might be in section 18, but yeah, there is a provision in there that the judge will seal these records unless there's a subpoena to do it. In other words, if you've been spied on but nobody catches you doing anything wrong, that would be something that would not be released to the public, is my understanding of that section of the bill.
Other questions? Vice Chair Flores.
Thank you, Madam. Excuse me. Thank you, Madam Chair, and thank you, Senator Hanson, for your presentation. I was just curious to know. I understand the reference to the Supreme Court case makes a lot of sense. Why we're doing this now. Did you get any feedback from different law enforcement agencies? To what extent we're utilizing them now? How often are we utilizing them? What's the process currently? I'm just curious to know just the backstory of what's happening presently.
Presently, we have, Ira Hansen, for the record, we have two main laws governing this, NRS 179-475, that was last amended in 2013, and that sets up when you're allowed to track electronic devices and communications. We also did in 2013 707, 600 through 650. Those are the current ones. This just builds on that, makes it a little stricter, and also kind of brings in more things that at the time were probably not considered electronic devices, and it also makes sure we're in compliance with Carpenter versus the United States, because some of our language was probably a little bit loose. My understanding, though, from talking to law enforcement people, for the most part, what I have in this bill is what they're trying to do already. This does codify it rather than just make it common law practice in the justice courts. Justice system, I should say.
Madam Chair, may I have a quick follow-up? Do you know of any instances where third-party entities are being utilized, or organizations, nonprofits, just that it's not the exact agency themselves, but maybe a private investigator, et cetera, and how that interacts with this bill and what the current law is now?
Thank you, Senator. I kind of giggle because I don't know for sure. I was tipped off, though, that is how the law enforcement agencies get around some of these types of things. They'll deny it probably, but by going through a third-party provider, basically, they can get the information without obtaining a search warrant. That is pure speculation on my part at this point, but I have heard that. So obviously, that is one. I think it's section. I think it's in section 14. Yeah, section 14, number 4. Any location information obtained in violation of the provisions of this section or evidence derived thereby is inadmissible in any trial, hearing, or other proceeding. In other words, if they do get it through a third-party provider, it would be inadmissible in a court of law. The bigger issue that you hit on, though, is it's getting honestly a little bit frightening how much the government can surveil everything we do already. Talking to some people about the federal laws on national security and stuff, George Orwell will be flipping over in his grave. You know, the big brother that was spying on us back in the book 1984. I mean, they have so many surveillance things that they do right now. It's on the federal level. This obviously is just a state level. But, you know, maybe we're always playing catch up, but that's the idea behind this bill, is to try to eliminate that kind of stuff happening and to make sure that everybody plays by the same rules if you are going to be potentially prosecuted for a crime in the state of Nevada.
Thank you, Madam Chair. Thank you.
I'm going to go to Senator Krasner next, and then Senator Ellison.
Thank you, Chair. Thank you for your presentation. So I thought the Fourth Amendment already covered this, tracking individuals by the government or government actors, including law enforcement. But my question is in section 14, subsection 2, subsection 2. So what we're looking at here is a governmental entity may obtain location information of an electronic device or unique identifier without a tracking warrant in the following circumstances. And then in that section 14, subsection 2, subsection 2 on page 4, if the owner or user of an electronic device or user of a unique identifier is a child who is less than 18 years old. So I'm just wondering why you want to allow the government to randomly track children under the age of 18 with no probable cause.
Ira Hans for the record. Thanks for the question. Actually, Section 14 does give the law enforcement community some reasons in emergency situations to not have to pursue getting the warrant. And that is already state law. If you go and look at, I think it's 175, 745, I think it was, 475, excuse me. They already have that ability. And obviously, we as they will undoubtedly testify today, there are situations where they have to act immediately, and they can't get a warrant. And that's why you'll notice in Section 14, 2, number 3, exigent circumstances make obtaining a warrant impractical. And there are times when they are going to need to do that. And as far as the user being a child who's less than 18 years of age, if you go behind that, you'll see that there are a series of things where they may need to do that. In other words, if a parent makes a request to have law enforcement check a child under the age of 18, you'll notice in there, if you read, there's a bunch of things about if the device is lost, if there's an emergency service that is required under 707-630, if the owner or user of the electronic device or the user of a unique identifier gives the government entity informed written consent. So that's where as a parent, you are responsible for your minor child, and this would be something I would assume that government could track simply by a written consent from a parent. So that's my understanding of that provision.
Thank you, Chair. So just clarifying then, in Section 14, subsection 2, subsection 2, you're saying that the government can track somebody who's 18 years of age or younger only if their parent or guardian gives consent to the governmental entity to do so? Is that your intent with the bill?
I think that is my intent, but yeah, it's a question I'll have to ask the builder after, because it does say if the owner or user of an electronic device or user of a unique identifier is a child who is less than 18 years of age, then the law enforcement people can do that without getting a tracking warrant. So it seems reasonable to me, in that I'm assuming that's if a parent contacts them and says, look, I got a juvenile that's giving me a hard time, can you follow that? They wouldn't need to go and get a probable cause search warrant under this section of law. Now, obviously, once they're 18 and they're on their own, then that would change.
Senator Ellison, did you have another question?
Yes, thank you, ma'am.
I did say it.
Mr. Hanson, Senator, it seems like that's the process that's happening right now. If the police need to find out if a criminal was within an area using a cell phone, they could take that cell phone and bounce it off different towers and find out where he's at. Isn't that correct?
Yeah, Senator, that would be correct if they get a search warrant for probable cause. You can't just randomly say, I think that Ira Hansen is committing a crime and we should just spy on him to see where his cell phone locations have been. If they in fact think they have probable cause that Ira Hansen is committing a crime, they need to go to a magistrate, submit that evidence to the magistrate, because I, as a person, have a reasonable expectation that I don't have I don't have to prove to the government that I'm not committing a crime. They have to prove that I do, and they need to show the evidence to a magistrate, then get a tracking warrant under this bill. Then they can spy on my cell phone's locations or other electronic devices.
Could follow up, ma'am? Because most of that, I didn't know you had to get a warrant to do that, but I know murder cases, kidnapping, some of these serious crimes that they can hit these towers and find out where they were at, and even follow the phone of the victim that they might have had. So I didn't know that they had to go to the process to try to get a judge to sign off on that, so.
Thank you, Senator Ellis. And Ira Hansen again. If in section 14, 2B, it does say the law enforcement community can respond to a call or request for emergency services by the owner or user pursuant to 707-630. That's emergencies, okay? Like you're saying, if there was a murder that was committed and they need to immediately track somebody that they think is involved in the murder, they are allowed to do that under emergency circumstances. However, the bill does have a provision that after 48 hours of pursuing that individual, then they have to go to a magistrate and get a tracking warrant to continue that effort if, in fact, they have not been successful in arresting them previously.
Senator Orenshaw.
Thank you very much, Chair Scheibel. Thank you, Senator Hansen. My question is on section 14, 2 and 3. Talk about the, I guess those situations where a law enforcement officer could try to, get that tracking information without a warrant in 2, and then 3 talks about a peace officer obtains location information without a tracking warrant in the manner described in paragraph D of subsection 2 shall not later than 48 hours after obtaining the location information apply for a tracking warrant that meets the requirements under section 15 of this act. If the application is denied, any location information or evidence derived therefrom is inadmissible in any trial, hearing, or other proceeding. It goes on and on. I just wanted to clarify, is it your intent in section 14 sub 3 that if, let's say, law enforcement felt that they needed to track me without a warrant under section 2, if your bill passed, and they find out I go to Jimmy's pool hall every night after work, and then later on, 48 hours later, they apply for this tracking warrant and the judge denies it, is it your intent that information that I go to Jimmy's pool hall after work every night not be shared with other law enforcement, not be something that they can, pass on to other authorities at all, that it just has to be disposed of, shredded, deleted, the information they got after the warrant was denied?
Senator Hansen, interesting question. Would they have to totally eliminate that? No, I think that could still be part of an investigation. However, at that point, they could not, because they have not given to a magistrate probable cause, and therefore you have a reasonable expectation that they can't spy on you unless a judge has said, you know what, this individual is hanging out the pool hall. The evidence that the law enforcement community has presented to me as far as probable cause is sufficient to spy on him. See if, in fact, he is doing criminal activity. On the other hand, if they go and present their evidence to a magistrate and he says, no, this is insufficient, this doesn't even rise to a level of reasonable suspicion, I'm sorry, I'm going to deny this search warrant, that doesn't mean that they can't continue to do an investigation, but it does mean that any evidence that they've tried to gather prior to that would not be admissible in a court of law unless they gather additional information and can return to a magistrate who then says, aha, now you've reached a basic status of status quo, or of probable cause.
Thank you, Senator. Thank you, Chair.
Other questions from members of the committee? So I want to clarify the devices that we're talking about. We're actually talking about 2 different types of devices, correct?
Oh, at least, yes.
Well, I mean, 2 large categories. We're talking about devices that people already have in their possession that
Correct.
law enforcement wants to utilize to track them. But then we're also talking about the tracking devices that law enforcement install on a suspect's car in order to track them, right?
Yes, that's already in law. What does allow them. Remember, we passed that, I think, last session. And I don't know, this doesn't directly deal with that as much as the current law does. They still have all those things. This adds kind of another tracking category to where they have any attempts to go through what would you call it? It's actually in the definition, so you'll have to pardon me. Some of this is over my pay grade as far as all the different definitions. But they would have to, the term is unique identifier. Okay, you have stuff on you that right now it won't even say Ira Hansen on it, but it may have number 345, and this unique identifier is something that they can apply for, then find out that 345 is connected to Ira Hansen, and then they can do the process of obtaining a search warrant through that. But they have to at least start with that unique identifier and get that through the hurdle of probable cause in front of a judge, and then the judge will say, yeah, okay, whoever this 1, 2, 3 guy is, yes, you can go through that identifier. Then when they go and get that number or identification from the cell tower people, they can then get a search warrant to go after whoever this guy is by name.
Okay, so in that example, if, we're looking at a crime that was committed and the law enforcement agency knows where the crime was committed and when the crime was committed, but they don't know who committed the crime, which is, I think, a common scenario. It sounds like you would not, this bill would prevent law enforcement from pulling the data about let's say there are 100 cell phones pinging off the tower of the victim's cell phone. This would prevent law enforcement from getting the names of every single person whose cell phone was within, the same cell tower radius as the victim, because they wouldn't have probable cause to believe that each individual person in the area was involved in the crime, even though that list of people who were in the area might be helpful to develop a suspect.
Ira Hansen, for the record. Under that scenario, yeah, obviously, if there were 100 people that were at a Radio Shack and the Radio Shack was robbed by one person, they would have to come up with something beyond. They could probably use that to begin an investigation, but as far as actually going into the data and then tracking the one person out of the 100 that have been in the whatever that got robbed, to literally track his movements, assuming it's a him, could be a her, I guess, track his movements, then yeah, they'd have to reach a level of probable cause before they can go through all 100 cell phone records, as I understand it. I think that's current law anyway. That isn't something unique to this bill.
So I know we will have law enforcement testifying here in a minute, but, I think I've had cases where, my clients have been at crime scenes and their phones have therefore pinged at those scenes. And sometimes they've focused on my client first, but in other cases they have pulled cell phone data to determine, that there were a whole bunch of innocent people there whose names I never get to see as defense counsel because they were not ultimately part of the suspect list. But I guess what I'm asking is I'm just trying to confirm that the intention here is that, and maybe I'm kind of asking it from backwards, but so I'm going to try to ask it forwards. Your intention here is, let's say I'm a detective and I know that somebody was murdered on the corner of 1st and Main Street at 2 p.m. on Tuesday. You would not want me, Detective Scheibel, to be able to pull a list of all of the cell phones that were at the corner of 1st and Main Street on Tuesday at 2 p.m. and get a list of those names in order to start my investigation.
Honestly, I'm not sure that is the intent of this bill, because in the scenario you just gave, that would seem reasonable to me. We know of the 100 people that were near that street corner, one of them most likely was the one that committed the crime. So I don't know, it'd be interesting to have, because I know the public defenders are going to talk about the bill and the law enforcement. This may be a little over my pay grade. My intent is obviously to protect people, to make sure that before they're investigated, the amount of randomness is eliminated as much as possible. You should be completely free to not have the government going through your cell phone records. Now, in a case where there are 100 people on a street corner where a murder occurred, that may be reasonable suspicion that would raise it to a probable cause and say, okay, of the 100 people we know were in this location, we want to have a search warrant. I honestly don't know how the law enforcement does it currently, but I do know there's laws governing how they do it. And then after that data has been sifted through, if they did get probable cause and a search warrant that would be broad enough to encompass 100 people who may have been near the crime scene, the 99 that had nothing to do with it would be able to have their records basically expunged. And then the one individual that they think is the perpetrator, they would then be able to further follow the individual's records. That's my understanding. But like I said, I may be getting into the weeds in a field where I don't have the level of expertise to really explain it. So I got the public defenders and I got the prosecutors here, so I'm sure they'll say, Hansen's way off on this, and here's where he's wrong. the bottom line to me is, look, we need to have, before the government can commit a reasonable search, they have to have some level of probable cause. And now that we have so many different types of ways for the government to basically spy on us, we want to keep a lid on that as much as reasonably possible and make sure that when they do that, that those Fourth Amendment protections are preserved within all reasonable levels.
So, I agree that we want to protect the Fourth Amendment and people's rights to privacy. You also started your presentation by, mentioning that when the Fourth Amendment was drafted, we couldn't really imagine the kinds of technology that we would see today. However, case law, Carpenter included, has evolved to address all kinds of technology, certainly not everything, but a lot of different technology. So my question is about what whole does this address? What type of technology are law enforcement officers accessing without a warrant? Because I've never seen a pen, a trap and trace, a tracker done without a warrant. So what kind of technology are they? Let's even take it to the full extreme of the argument and say they are bad actors. Let's say they are doing this for nefarious reasons. What is the practice where they are exploiting the loophole to say, hey, the Fourth Amendment doesn't explicitly say we need probable cause to do this search, so what is it that they're doing?
Well, Ira Hansen again. I'm not completely sure that any of the things that are in this bill are not currently practiced by them. What this does do is this puts it in statute. So there is a clear guideline for the courts and for the law enforcement community to follow. So could I tell you exactly, I literally in the last week learned what a unique identifier is. Are the law enforcement guys misusing unique identifiers? I don't know. What I do know, though, is because of the constant evolution in technology that these unique identifiers can be used to track people. And if they are going to track people, then I think there's a good reason for us to have, make sure that there's a good reason that they can use that. And, while this deals with just Nevada stuff, I think the bigger red flag for me, and it isn't in this bill, but just the overall ability of the federal government especially to spy on us in so many different ways. So what my bill is intended to do is to make sure we limit it as much as possible, and whether or not they're currently misusing potentially some of the things that are in this bill, I honestly can't say yay or nay to. What I can do, though, is going forward as these technologies evolve, that we have in statute the guidelines to make sure that your Fourth Amendment rights are protected.
I mean, that makes sense, and I don't like the government spying on me either. And so I guess my last question is just about, unintended consequences. And, something that we haven't really talked about, I hadn't really thought about is, other uses of the tracking technology. While we were sitting here, I think a bunch of us got an Amber Alert. And so that tells me that the government is utilizing some kind of technology to know where I am geographically, because the Amber Alert was for Fallon, Nevada. And I don't live in Fallon, Nevada. I don't have a home in Fallon, Nevada. I've been to Fallon, Nevada. But I'm geographically close to Fallon, Nevada right now. And so I conclude that that's how I got that Amber Alert. So it seems that the government's also using this technology for the purpose of protecting the public and providing information. So does SB 361 adequately account for those other uses of location data?
Ira Hansen, well, thank you, Madam Chair. My goal, obviously, is if there are areas like that that are not covered in the statute, of course, obviously, I'm totally open to amending all of this. I met with the prosecution folks. They had a couple of things that they're going to mention in their testimony in opposition to the bill. And just so you know, I'm fine with that. Obviously, we don't want to have it so that whoever puts out an Amber Alert may somehow be found guilty of violating a Fourth Amendment thing. I don't think so. Fourth Amendment does say unreasonable searches and seizures. An Amber Alert, I don't think even is a search. It's more like a warning. So I don't know if that would apply. But yes, you're correct. There may be things that we have in drafting the bill that we may have overlooked. And if that's the case, and it's also why we meet every 2 years, is to make corrections on. It's very interesting hearing Mr. Jones talk about the bill from 341, and that's 10 years ago, and we're correcting, or at least the public defenders are trying to correct something that we had an agreement on between the public defenders, and the public defender at that time was Steve Yeager from Clark County. So, but yeah, we're always trying to fix it. And obviously, you know, Maggie Carlton's old adage, don't let the perfect stand in the way of the good. I think if I'm going to err, I want to err on the side of protecting the people against unreasonable searches and seizures by the government. As you and I know so well, the government has all the advantages in this. I mean, when you get right down to it, the government has the investigators, the prosecutors, the police force, and if you're a poor indigent person, you're lucky to have a public defender who generally has 50 other cases at least. So when after viewing this, being on this committee for 8 terms, the one thing that came through loud and clear to me is we need to watch out. I want to have law enforcement do the best possible job they can, but there are a whole lot of people out there that aren't financially able to get top-rate attorneys and things like that, and they don't know the law, and so many cases that something as simple as the Bill of Rights is their only fallback position to protect them from the awesome powers of the state. So that's kind of my spiel on this, why I'm involved in this. I don't think the average person, even if they have committed some kind of offense, should ever be subjected to some sort of big brother government overreach where you're just overwhelmed by the forces and the finances and the investigation powers of the state. And that's what I think the founders of our nation really, that's why they gave us the Bill of Rights. They recognized that the state, remember, they were often against the state. Everybody that signed the Declaration of Independence, 56 men, they literally signed their death warrants there. If they would have lost that war, they would have been literally hung, drawn, and quartered for treason. So these guys were pretty adept people, disproportionately lawyers, I might add, too. So anyway, I don't want to give an Ira Hansen TED Talk like you call them. But yeah, there is a factor there, and that's why I'm always very sympathetic to the public defender side of this thing, because they're the ones that, they don't have the glamour side of this. You know, when the DAs go and prosecute a murderer or a rapist, everybody, yeah, go get him. But when these guys do their part and they find some issue that the state has not fulfilled its obligation to prove every element of a crime, then they're the bad guys because they've got the crook off. But in our system of government, the state has the responsibility to prove every element of a crime. You never have to prove that you are innocent of a crime. And I think we got to keep that in mind when we think about these kind of things. Anyway, thank you, Madam Chair. Is there any, I'm learning as I go, and hopefully some of the things I've said, if I have said something in error, I hope the public defenders or the prosecution folks will be happy to come up and correct it. My goal in all this is not to try to sneak something through. My goal is simply to make sure as the technology evolves that we keep those protections in place.
Thank you. I appreciate that. Other questions? Okay. I'm not seeing any other questions. So at this time, I will open it up for testimony in support of SB 361, inviting anybody who wishes to testify in support in person down to the front here in Carson City, as I don't see anybody in Las Vegas. But if you're hiding in the wings, come on down now.
Good afternoon, Angela Knott from the Washoe County Public Defender's Office, ANGELA. KNOTT. I had prepared a little script, but I think instead I'm just going to try to answer some of Senator Hansen's concerns with the back and forth. The first one being the concern that there's a murder, someone's pinging off the cell phone towers. How can they get the information to start to get to these warrants? Which I only discovered a few weeks ago with AB 172. They have something called administrative subpoenas, which is kind of a power of law enforcement to preliminary get this information, and then they use that information that they're already getting to get the warrant. So I think what SB 361 is doing is trying to provide better guidelines for law enforcement, right? So I don't think it's that difficult to go to a judge and ask for a warrant when you have a murder and you have some numbers. You're like, look, one of these cell phones belonged to somebody. Can we get a warrant so we can look at those numbers and look at who they belong to? And from there, start the next process of any kind of warrants that they need. This is not a difficult process, and I think SB 361 is taking Supreme Court case law and the Fourth Amendment and just bringing it into a statute so that everybody knows what we're supposed to do, right? We litigate Fourth Amendment issues all the time as criminal defense attorneys. I think that's the majority of our practice, is trying to fight law enforcement when we don't believe that they've done their job correctly. So we support SB 361 because we believe it's just trying to help clear guidelines for everyone, not just our defendants or us for our job, but also for law enforcement. And I think that answers most of those questions, unless there was another one pending.
Doesn't look like we have any further questions, so thank you, appreciate it.
Thank you.
Paloma Guerrero, Paloma-Guerrero, on behalf of Clark County Public Defender's Office, and will echo Ms. Knott's comments. Thank you.
Good afternoon. My name is Tia Smith, T-I-A-S-M-I-T-H. I'm a policy attorney with ACLU of Nevada. While I was listening to the hearing, I did a quick Google search and I found some data I thought you all might be interested in. It's an article from February 27th, 2025, titled "Apple, Google, Meta are sharing more data with the US government than ever." It says over the last 10 years, Apple, Google, and Meta have handed over data on 3.1 million accounts to the US government. The number of times officials have requested user data from these big tech companies has skyrocketed to an average of 600% over the last 10 years. And Apple, Google, and Meta comply with about 80 to 90% of these requests. And so these are just requests. They're not necessarily saying, we have a warrant, you need to give us the information. They're just asking for it, and they are usually getting it. So ACLU of Nevada supports SB 361. Big thanks to Senator Hansen for starting this discussion and trying to establish these clear guidelines. Thank you.
All right, I don't see anybody else coming down in support of SB 361 in person, so we'll go to the phones, please, for support testimony on SB 361.
Thank you, Chair. If you would like to testify in support of Senate Bill 361, please press *9 now to take your place in the queue. Chair, the public line is open and working. However, there are no callers wishing to testify in support at this time.
All right, then we'll go to opposition testimony on SB 361. Come on up to the front here to testify in opposition.
Good afternoon, Madam Chair, members of the committee. Jason Woodard, J-A-S-O-N-W-O-O-D-A-R-D, Nevada Sheriffs and Chiefs Association. We are in opposition of SB 361. Both the Fourth Amendment and current law require that law enforcement to meet a rigorous legal threshold when seeking digital data and GPS tracking information. Section 14, subsection 3 of this bill's language requires a warrant application even in scenarios where there are valid exigent circumstances, and unnecessarily requires law enforcement to obtain warrants even when the data obtained on the tracking devices results in the resolution of the case in less than 48 hours. With the evolution of technology, the use of digital tracking devices and data have become a staple of law enforcement investigations. Nevada jurors expect this type of investigative evidence and information at trial, and this evidence can only be presented after judges hold it was not obtained through a violation of the Fourth Amendment. The law already requires that law enforcement apply for and receive a warrant to obtain and utilize these important tools and information during investigations. The use of these devices or information in exigent circumstances are extremely rare, but when necessary are very much so. As an example, during the calendar year of 2024, one of the larger Northern Nevada police agencies executed only 35 exigent phone ping orders for emergent situations such as a missing endangered person, kidnappings, threats to public safety, and homicides. Additionally, that same agency in the same calendar year placed only 23 tracking devices, all with warrants and none under exigent circumstances. To be clear, we do not utilize private investigators or third parties to circumvent the Fourth Amendment requirements during our investigations. We believe this bill unnecessarily complicates the existing statutory framework enhancing protections to the subjects of the investigations. For these reasons, we oppose SB 361 as currently written. I'd like to add that I'm a 26-year law enforcement veteran, and I spent the majority of my career working major investigations to include homicides, fugitive investigations as part of a U.S. Marshals Fugitive Task Force team, as well as undercover operations. So I do have a familiarity with these particular scenarios and these types of devices. What I would ask you to consider is that, yes, this technology continues to evolve, but there is a necessity for all of these cases to be evaluated on a case-by-case basis, and the law provides for that currently. Thank you.
Good afternoon, Chair Scheibel, Vice Chair Flores, and members of the Senate Judiciary Committee. Jennifer Noble, Jennnifer, Noble, on behalf of the Nevada District Attorneys Association, in opposition to Senate Bill 361 this afternoon. But we do want to thank Senator Hansen for the time he took to meet with us and for the robust discussion that we had in his office, the type I think that we should always have when we're talking about Fourth Amendment protections. I also want to sort of pick up where this committee left off during the support testimony. In that Carpenter decision, Chief Justice Roberts quoted, in part, Justice Frankfurter, and he said that when considering new innovations in airplanes, such as airplanes and radios, we must tread carefully in such cases to ensure that we do not embarrass the future. At the beginning of this hearing, or close to it, Senator Krasner asked an excellent question, or made an excellent observation. I thought the Fourth Amendment already covered this. It does. In Arizona versus Evans, the United States Supreme Court made clear that suppression of evidence obtained pursuant to a search warrant should be ordered only on a case-by-case basis and only in those unusual cases where it will further the purposes of the exclusionary rule, and that's to deter law enforcement from violating the constitutional rights of anyone in this room, anyone in this country. The Fourth Amendment applies to this, and those questions can be extremely specific. They require courts to apply constitutional principles to sometimes complex and changing fact patterns. This individualized approach benefits the prosecution, the defendant, and the interests of justice. And to be clear, it is judges, and it is constitutional case law, not district attorneys, not law enforcement, who ultimately decide whether there is an exception, such as exigency, or such as the good faith exception to the warrant requirement, that applies. In United States versus Leon, the United States Supreme Court recognized that good faith exception when it talked about an officer acting pursuant to a warrant that appeared to be valid. And it outlined the doctrine of the good faith exception to the warrant requirement. So our concern here is with section 14.4, and I should have started with that maybe. And what that attempts to do, and valiantly perhaps, is codify a complex constitutional doctrine of the Fourth Amendment, the exclusionary rule, into a subsection in a Nevada statute. And I would submit to you that that is not a good idea for defendants. It's not a good idea for the state. And that is because, quite simply, these are case-specific inquiries, and we have a robust history and lots of constitutional case law that can guide a court's individual analysis when it's analyzing a purported Fourth Amendment violation. Finally, with regard to section 14, the way it's written, as written, it appears to allow a defendant to assert that a warrant is invalid, or I'm sorry, that the fruits of the warrant should be suppressed based on a purported violation of a victim's constitutional rights. So it gives standing where there would not normally be standing under United States Supreme Court case law. For those reasons, we oppose the bill. Thank you.
Good afternoon, committee. For the record, Tom Morley, representing the Nevada Press Association and the Las Vegas Review-Journal. The client has two specific sections of concern. One is allowing the public to serve as a check and balance system on governmental power is the purpose of NRS 239.001. And the second one would be we request public oversight and feel sections 19 and 20 are not necessary and would undermine the public's ability to be a watchdog of our government.
Good afternoon, Chair Scheibel, the Senate Committee on Judiciary. My name is Chris Reese. It's R-I-E-S. I represent the Las Vegas Metropolitan Police Department. First, I'd like to thank Senator Hansen for meeting with us this morning, for giving us the opportunity to address some of our concerns. However, we are in opposition of SB 361. Instead of echoing my colleagues from the Washoe County District Attorney's Office or the Nevada Sheriffs and Chiefs, I'd like to draw attention to Section 15, that tracking a device would only be limited to a person who is actually committing the crime. It would not allow for a warrant to be issued to, say, a kidnapping victim, their phone, and would then possibly give standing to the suspect's defense to get the evidence suppressed. I would also like to mention that unless an exigent circumstance or emergency is present, Apple, Google, and Meta all require search warrants anyways. And for all this, we oppose Senate Bill 361.
Good afternoon, Chair Scheibel, members of the committee. Jason Walker, Jasonwalker, representing the Washoe County Sheriff's Office, testifying in opposition to Senate Bill 361 for all the previous comments.
I don't see anybody else coming forward to give opposition testimony on SB 361 in person, so we'll go to the phones, please, for opposition testimony on SB 361.
Thank you, Chair. If you would like to testify in opposition to Senate Bill 361, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition to Senate Bill 361, please press star 9 now to take your place in the queue.
Good afternoon, Cyrus, H-O-J-J-A-T-Y. I stand in opposition. I will ditto the previous commentators. Thank you so much. Appreciate it.
Chair, the public line is open and working. However, there are no further callers at this time.
All right, thank you. We'll go to neutral testimony on SB 361. Anybody wishing to give neutral testimony is invited up to the front now. I don't see anybody coming up in person, so we will go to the phones for neutral testimony on SB 361.
Thank you, Chair. The public line is open and working. However, there are no other callers at this time.
All right, then that brings us to the conclusion of testimony. I'll invite the sponsor back down to give closing remarks.
I'll make it quick. Ira Hansen again. On the Carpenter decision, it was interesting. It was a 5-4 vote, and the 4 liberal justices and Chief Justice Roberts voted, and the ones that I'm normally more aligned with, including the law enforcement guys, were on the other side. It was 5-4. So of the 20 sections of the bill, there are only 2 sections that anybody actually mentions specifically. So I think we can work out some of those bugs with them. The overall idea, it sounded like, was, look, we're already pretty much doing this anyway. We may not want to have it codified because we want to leave it up to the flexibility because of the provisions, especially in 14.4. I don't really see any reason, if they're already doing it anyway, why it would hurt anybody to have it codified, especially only talking 30 or 40 cases a year they're doing this. So anyway, I will work with both sides on this and see if we can amend it to everybody's satisfaction. And in this case, you know, we always hear Ira Hansen is the most conservative member of the legislative body, and I'm kind of proud of that. But in this case, I seem to be siding with the more liberal elements in the Nevada Legislature. So sometimes I'm right, and in this case, I'm pretty sure I'm right, and I'm aligning with some people that most of the time, like ACLU and others who got a 0 rating from the ACLU a couple decades, or a couple of sessions ago too. So maybe I'll get it up to like 5% this time or something. Anyway, thank you, Madam Chair, for the hearing, and I will work on getting this cleaned up.
Glad to hear we're having a good influence on you. Oh, sorry, the record didn't catch that part. No, he says it goes both ways. It does. All right, I will close the hearing on SB 361, and that brings us to the final item on our agenda for today, which is public comment. Anybody wishing to give public comment is invited to come on down right now, but I don't see anybody coming to give public comment in person, so we'll go to the phones, please, for public comment.
Thank you, Chair. If you would like to provide public comment, please press *9 now to take your place in the queue. Chair, the public line is open and working. There are no callers at this time.
All right, then that brings us to the conclusion of our meeting. We will be meeting again here, same time, same place tomorrow. Until then, we are adjourned.